5 seconds to go. Start. Leave granted. The present appeal arises from the judgment and order dated 31st January 2019, passed by the High Court of Punjab and Haryana at Chandigarh in RSA number 3818 of 1987. The High Court allowed the regular second appeal filed by the respondents herein original plaintiffs, setting aside the judgment of the first appellate court and restoring the decree passed by the trial court in favor of the plaintiffs. Aggrieved by the High Court's decision, the appellant's original defendants, namely the State of Haryana and the Public Works Department (PWT), have preferred this appeal. The facts of the case leading up to the present appeal are as follows. The dispute pertains to a piece of land measuring 18 biswas pukhta comprised in Khasra number 2348 10 biswas and Khasra number 2458 8 biswas situated within the revenue estate of Bahadurgarh, Haryana. The land is located on both sides of National Highway number 10, which connects Delhi and Bahadurgarh. On 28th March 1981, the original plaintiffs, namely Shri Amin Lal and Shri Ashok Kumar, filed a suit for possession of the suit property before the Court of Sub-Judge First Class Bahadurgarh. They claimed ownership of the land based on revenue records and alleged that the defendants had unauthorizedly occupied the land approximately 3.5 years prior to the filing of the suit. The plaintiffs contended that despite repeated requests and legal notice served under Section 80 of the Code of Civil Procedure 1908, the defendants failed to vacate the land. The defendants, the State of Haryana and PWD, contested the suit by filing a written statement dated 17 September 1985. They raised preliminary objections asserting that they had been in continuous and uninterrupted possession of the suit land since 1879-80. They claimed that their possession was open, hostile, and adverse to the plaintiffs, and as such they had become owners by way of adverse possession. The defendants also contended that the land had been used as a store by the PWD and its predecessors entities, including the District Board and Jilla Parishad, for over a century. Based on the pleadings, the trial court framed the following main issues: whether the State of Haryana has become owner of the suit land by way of adverse possession, whether the plaintiffs have no locus standi to file the present suit. The plaintiffs examined 7 witnesses and produced revenue records, including copies of Jamabandis exhibits P1 to P9. The defendants examined 10 witnesses and produced various documents, including revenue records dating back to 1879-80, exhibits D1 to D22. On 2nd May 1986, the trial court decreed the suit in favor of the plaintiffs. It held that the defendants had failed to prove that they had become owners by adverse possession. Mere placement of bitumen drums and construction of a boundary wall in 1980 did not constitute adverse possession. The plaintiffs had locus standi to file the suit as they were recorded as owners in the Jamabandis. The defendant's possession, if any, was permissive and not hostile. Aggrieved by the trial court's decision, the defendants filed an appeal before the District Judge Rohtak. The first appellate court, after reappreciating the evidence, allowed the appeal on 8th October 1987 and dismissed the plaintiff's suit. The appellate court held that the plaintiffs failed to prove their ownership as they did not produce the sale deeds or mutation records establishing their title. The Jamabandi entries in favor of the plaintiffs were doubtful and appeared to be manipulated. The defendants and their predecessors had been in continuous possession of the suit land since 1879-80. The defendant's possession was open, continuous, and adverse, thereby perfecting their title by adverse possession. The plaintiffs were attempting to grab the land by manipulating revenue records. The plaintiffs filed RSA number 3818 of 1987 before the High Court of Punjab and Haryana, challenging the judgment of the First Appellate Court. The High Court framed the following substantial questions of law: whether the state can set up the plea of adverse possession, and does it imply admitting the title of the plaintiffs; whether the judgment and decree of the lower appellate court suffer from illegality and perversity. The High Court allowed the appeal, holding that by taking the plea of adverse possession, the defendants impliedly admitted the title of the plaintiffs. The state cannot claim title through adverse possession against its own citizens. The defendants failed to specifically deny the plaintiff's title as required under Order 8, Rule 5 of the Code of Civil Procedure. The possession of the defendants was permissive as evidenced by the Misal Hakiyat of 1879-80. The First Appellate Court erred in shifting the burden of proof onto the plaintiffs and in not appreciating the evidence correctly. Aggrieved by the High Court's judgment, the defendants, now appellants, have approached this court. We have heard Shri Vikramjit Banerjee, learned Additional Solicitor General for the appellants, and Shri Santosh Paul, learned Senior Counsel for the respondents. Mr. Vikramjit Banerjee, learned ASG, appearing on behalf of the appellant, the State of Haryana and its authorities, has argued that the High Court erred in overturning the well-reasoned judgment of the First Appellate Court, which had dismissed the plaintiff's suit. The gist of his arguments is as follows. The appellants assert that the plaintiffs did not produce any substantive evidence to establish their ownership of the suit property. Despite opportunities provided by the trial court and the First Appellate Court, the plaintiffs failed to present any sale deeds or title documents. Mere reliance on Jamabandi revenue records is insufficient to confer title, as revenue entries do not create or extinguish ownership rights. The appellants further argue that the High Court incorrectly shifted the burden of proof onto the defendants to establish who the real owner is. In a suit for possession, the plaintiff must stand on the strength of their own title. The appellants cite precedents to emphasize that the weakness of the defendant's case cannot be a ground for granting relief to the plaintiffs. While acknowledging that the state cannot claim adverse possession against a private individual, the appellants maintain that they have been in continuous peaceful possession of the suit land since 1879. Under Section 110 of the Indian Evidence Act 1872, such possession raises a presumption of ownership in their favor. Moreover, the plaintiff's suit is barred by limitation under Article 65 of the Limitation Act 1963, as they failed to challenge the appellant's possession within the prescribed period. The appellants contend that the plaintiffs should have filed a suit for declaration of title before seeking possession, especially when their ownership was in dispute. Without a declaratory decree establishing their title, the plaintiffs are not entitled to a decree for possession. The appellants highlight that the First Appellate Court had termed the plaintiffs as land grabbers who manipulated revenue records to claim ownership. The High Court, however, did not address these observations or the detailed reasoning provided by the First Appellate Court. Stop.